Actually dropping into those upper 70s, low 80s for high temperatures going into a late week, and we'll keep those rain chances limited heading into next week.
We're liking it, see? It's the wearing of the fall colors that really did it.
It really helped.
Cheers to that.
Thanks, lady. Thanks for watching WAAY 31 News at 10. Stay right where you are. WAAY 31 Law Call is next.
It's WAAY 31 Law Call.
Welcome to WAAY 31 Law Call. I'm Robert Lane, sitting in for Sharon Doviet. Now, don't panic. Sharon will be back next week. We love her too, and she'll be back next week. So, here's a question for you. How many lawyers do you think there are in America? Too many is the wrong answer. That was so rude of you. There are 1.3 million. But only one is here live on a Sunday night to answer your legal questions. Give us a call at 256-536-0077. And who is that one attorney live to answer your question?
I'm important. I'm one out of 1.3 million.
It's Michael Timberlake of Timberlake, League & Brooks. Hey.
Good to be here.
So are you ready for You Make the Law Call? This one is right up your alley.
Yeah, this is always fun. You know, we try not to watch the video so we can watch it here, and you get instant reaction, real time.
Okay, you're at a railroad crossing.
This is not going to be good.
The gate has come down. The lights are going. What's going to happen? Oh,
That's not a good thing. Yeah, it's amazing to me how many instances you see where people either go around bars that are down, and for whatever reason to try to beat a train. This in a situation looks like it's they're on the tracks and they could be stopped. They could have had mechanical problems. If you got mechanical problems when you're on a train track, get out of the vehicle. And I hope these people did. But when you see those lights and warnings come on, you got to stop your car before you ever get to that point. So it's important that the train has the right of way, and that your obligation is to stop and make sure that the train doesn't hit you.
so if you get stuck on, whose fault is it?
Well, I mean, if the train has the right of way. So if you're stuck on their right of way, even if it's your vehicle has malfunctioned, and then it typically would be your responsibility.
Okay. Well, if you have a question or even a comment, give us a call here. It's 256-536-0077. You can use that same phone number and text us if you don't want to be live.
Absolutely.
Listen, there's a new law coming into Alabama.
Right.
Starting. It's called Parker's Law.
Right. So it's really interesting because it comes into effect October 1st, and it applies to women that are nursing. And basically, there was an interesting scenario that came up where someone that had a newborn and that was nursing their child got called for jury duty. And she showed up for jury duty, as she was required to do, with her newborn child and needed to nurse. She didn't have anybody to keep the child or any way to nurse the child without her. So the sheriff's department, the bailiffs or whatever, didn't know what to do. They told her she needed to go, or they were going to call DHR or whatever. And she was like, well, you're the ones that required me to come here. I didn't want to get in trouble for not showing up. So it made some press, and then the legislature kind of figured there was a solution to this, and they've passed legislation that allows women with a doctor's excuse that says they are actively nursing, they are excused from jury duty. So that's hopefully this problem won't come back up.
And that goes into effect October 1st.
Right, absolutely.
One other thing that's been in the news, Michael Timberlake is the smartest lawyer, and he always gets embarrassed when I say that. I'll tell you then, he's the smartest lawyer I know, and I know a lot of lawyers.
So I'm not the smartest of all 1.3, I promise.
I don't know, maybe. So explain to me, why is it such a big deal to lie when you're under oath?
I mean, it kind of goes back to the rules that they teach you in kindergarten. You can't lie. If you're going to live in a civilized society with other people, there has to be some limit on your behavior. So that if you actively tell dishonest statements under oath consistently, then you can't live in a society with other people if you do that. We can't have a we can't have a lawful society. We can't have a society that abides by the rules if people are not going to, if people are going to blatantly lie under oath when they're sworn to tell the truth. So that's really kind of the reason it's punishable by jail time. It's punishable by fine and contempt for not telling the truth under oath.
And proving that I'm not telling the truth.
Right. Well, I mean, in a lot of situations, it's not that hard. Especially if you're in front of a jury and somebody's making up a lie. Cross-examination is a great tool to be able to show the jury that they're not being truthful. And honestly, if you're not forthcoming with the jury or the judge and you get caught in the lie, it's probably 10 times worse than just if you had told the truth to begin with. So, when we, in our business, what we do is we tell people, look, we can deal with the truth. What we can't deal is with somebody that's going to be dishonest or gets caught in some kind of subterfuge or some kind of cover-up or something like that. That's much worse typically than the crime.
Okay, can I pick your brain on one other thing?
Absolutely.
I don't quite understand what a grand jury is.
Okay.
And why do we have them?
Right. So basically, in order to charge someone with a crime, it has to be something that law enforcement sees. If they see somebody doing something that's criminal, they've got probable cause or reasonable suspicion to arrest them and charge them with a crime. But if a law enforcement doesn't see the crime being committed and they're basing it on basically circumstantial evidence, then they have two ways. They can go to a magistrate judge and put the evidence out there and say, this is what we have. Do we have enough to arrest this person? But that only gives you the right to arrest the person. It's not as convincing as a grand jury indictment. So what you do in a situation where you've got a case that you want to bring, and it's going to be a case of some significance or any significance, you can present it to a grand jury, which is 12 people that are called in. It's not like jury duty typically. It's much more casual than that. They're presented with certain facts, and you say, if these facts are proven true, do you think there is reasonable suspicion or probable cause to make an arrest? If there is, then you can indict someone, go out and arrest them. So it's a way for prosecutors to bolster their credibility or test the credibility of their case. And before they ever get to the point where they're going into court.
But mostly grand juries just approve it.
Well, I mean, it's the saying you can indict a ham sandwich.
Right.
The reason that they say that is because a lot of it depends on the way the evidence is presented and the way the crime is described to the grand jury, and it's not beyond this person is guilty beyond a reasonable doubt. It's, is there enough evidence to bring charges against this person, arrest them, and find out other evidence?
We have a caller from Arab who has a question. Adade, what's on your mind tonight?
If you know someone lied under oath, what is the procedure to start to prove that, or how do you go about that? I'm very illiterate about such as that, but I know it happened. It happened to me.
Right. Well, I mean, it would depend on your position as the litigant in the situation. If you were a victim or a crime and somebody lied under oath, and you would go talk to the district attorney who was prosecuting the case, and they will see if they can prove that person was lying, and if it was material and it had affected the outcome of a case. Same or similar type of thing if you were a litigant in a civil claim. If you know the other person is lying or a witness is lying, bring that up to your lawyer and let them know. If you're just simply a witness in the case, then you can bring it up to the court's attention. Talk to the bailiff and say you need to talk to the judge about something. You think this person was lying under oath, and here's why. And then they can disclose that to the lawyers, and they can talk about how what might happen if that person was telling the truth.
Well, Dave, thank you so much for giving us a call. Now, if you have a question, you can give us a call here, 256-536-0077, or you can text that very same number and Michael can read it on his pad here.
Right.
Listen, I have a question from Gabriel. This was an email question that was sent in a little while ago.
Okay.
Okay. I always have a yard full of kids playing football and soccer with my boys. If one of these kids gets hurt somehow, could I be sued?
It depends, really. You know, it depends on, you know, if they are on your property and there's something wrong with your property that you need to deal with, and that you know about it and you know that it should be repaired and it creates a hazard to someone else, and you don't tell them about that, then you could potentially be responsible for their injuries that result of that. If you are out at a park and you're the coach on the soccer team and a kid gets hurt, you know, basically and there's nothing that you've done or could have done to avoid it, then it's probably not going to be a situation where the coach is going to be responsible simply because there was an injury.
Okay, so those forms we sign saying, you know, we're not going to sue anybody, it doesn't matter who gets hurt.
Right, right.
Valid?
They're not valid for minors. And you, even if you're a parent or an adult and these are your children, you cannot sign away your children's rights. So there's things that you sign at the skateboard park, at the trampoline park, and you go to the paintball guns, those types of things. Those are not valid. Now, a lot of businesses use them because people think that they're valid, and if something happens, then they won't pursue anything. But if it is for a minor, and the parent can't sign away the rights of a minor, so that if the business actually does something that's negligent or unreasonable, and it results in an injury to a minor, someone that's not 19 years old of Alabama, then those waivers are not good if they're just signed by the parent.
Well, we got to take a break. If you have a question, give us a call here. Thinking of robbing a bank, could you be liable? Could it hurt you? Who knows?
Don't think about robbing banks.
Give us a call. We'll be right back.
Your rights, your calls, live. Presented by the Tennessee Valley's award-winning personal injury and wrongful death law firm, Timberlake, League & Brooks. Featuring the knowledge and experience of Attorney Michael Timberlake, Attorney Will League, Attorney Heath Brooks, Attorney William Maservi. And hosted by broadcaster and family law attorney Sharon Doviet. This is WAAY 31 Law Call.
Welcome back. Now, if you have a question or a comment, you give us a call, 256-536-0077. I'm here with a real attorney, Michael Timberlake. And you have an event you want to tell us about.
Oh, yeah. So, a lot of people say, well, what do you do when you're not law calling or lawyering? And so sometimes we like to say. So we had a great time at Concerts on the Dock, which is at Low Mill. They do a concert series in the spring and the fall every year, and our firm, we're pleased to be sponsors of it. We had a great time. The local band Snake Doctors, which are very popular amongst the people my age, really enjoyed it, and it's always a good time, and it's so we were happy to be able to sponsor that event.
And something else that you sponsor, Broadway Theater League's Wheelchair Brigade.
Absolutely.
Which will pick you up in a wheelchair, and there you see it.
Yep.
And they'll take you right to your seat. And what is the show that starts this Tuesday?
Caveat, they will not pick you up from bars downtown and take you to the Civic Center, only in the reasonable area of the Civic Center. But this starts on Tuesday. I think they're running Tuesday through Sunday, and it's Back to the Future, the musical, and there are tickets available, and we're another organization that we're proud to support.
And they have had a DeLorean sitting out there for a little bit. So
cool.
We'll see if that's there.
Well, if it gets to 70 miles an hour, it'll go away, right?
Now, someone did text you a question, right?
Yeah, so this is interesting. So we had a lady text us about a depreciation on a vehicle. So a vehicle was hit by another car. Insurance company paid for the repairs, but they're asking about diminution in value or depreciation of the vehicle as a result of the damages from the wreck. And that is, part of your damages that you can collect if somebody else injures your vehicle. It's the cost of repair plus the diminution in value. Diminution in value is typically something that we can collect on newer vehicles. The older the vehicle gets, the more difficult it is to collect diminution because reasonably the repairs might increase the value of the car instead of diminishing the value of the car. In this situation, the car had been in a wreck before and the insurance company didn't want to pay depreciation, but apparently the wreck was only involving an incident with a raccoon, and so they brought that up to the insurance company, but they didn't get a lot of headway. Diminished value, a lot of it is what are we really talking about here? If you're talking about a $40,000 car that has $10,000 worth of damage, yeah, you can probably look, to, sometime 10 to 15% diminution. If you're talking about a $4,000 car that's got $200 worth of damage, that's 25 years old, it's a lot different story.
Did she mention what happened to the raccoon?
I bet it. I bet it didn't end well for the raccoon.
Listen, let's find out what Sandra has on her mind. Sandra from Huntsville has been waiting. Thank you so very much. You're on the air.
Yeah, can we talk some more about that lying in court?
Sure.
Okay. I just went through a divorce, and my ex absolutely lied on the stand. My lawyer knew it. His lawyer knew it. The judge knew it, but nobody did anything about it. And they're going, well, it'd take a lot more effort to do this and follow through. And there were documents that would show that he was lying, but nobody did anything about it. And several lawyers said, well, everybody lies on the stand. So is that truly the way it is?
Well, I mean, basically in the situation where there's the truth or the credibility of a witness is in question, in a divorce case, a family law matter, a judge is going to take that into consideration when they're making the ruling. So when it becomes apparent that somebody's not trustworthy, that the judge doesn't have to stand up and say, you're lying, throw him in jail or throw the person in, or fine the person for not telling the truth. But when the judge goes back to consider all the evidence in the case and make a decision about who gets what person's, what's the responsibility of the persons, the judge is going to consider the credibility or not of the people that testified in the trial. And whether something they testified about that was material to the outcome of the case, and that they lied about it, that's going to come back to haunt them. And like I said, it's more, the subterfuge is worse typically than just telling the truth. The judge can use that against somebody and basically punish them for not being credible to the court.
Now, a number of people in your firm now can practice in Tennessee.
Yeah,
Is that
absolutely,
right?
absolutely.
Well, that's going to be important because Susan from Tennessee has a question for you.
Yeah.
Susan?
Yes. My daughter was involved in a car wreck last year, and I guess my question would be, how do we, they said we had a year to collect the money. Well, we were trying to call the lady several times from the insurance company, but she wouldn't return our calls. So what do we do now?
Yeah, I mean, so one of the most important things that we learned when we got barred in Tennessee was that Tennessee's got a 1-year statute of limitations, whereas Alabama has a 2-year statute of limitations. So you really kind of in a situation in Tennessee, you've got to get working on things, much quicker. You have to do investigation quicker. You have to get evidence quicker. Have to, maintain contact with insurance companies, push them harder. If you are at a situation where that has not worked, you're not able to negotiate with the insurance company, not able to get them the data that they need to make offers, or they're just ignoring you, then what you need to do is move forward with litigation. You want to make sure that you have a complaint filed in the courthouse, not just a call into the adjuster or a letter into the adjuster to make a claim. You have to have a complaint filed in the courthouse within 1 year of the date of the injury. So, you got to move quickly, and if you're getting close to that time frame, you need to talk to an attorney as soon as possible to make sure that, they can, they can preserve your rights. Because if you let that year go, you cannot bring it back. There's nothing you can do.
It's over forever.
It's over forever, right? No matter how severe your injuries were, it's, there's a few exclusions, and if you're a minor, it's extended, but for adults, it's very hard after that time.
We got an email here. Is it true that dogs get a free bite? Also, I want to know, do raccoons get a free bite?
Raccoons are a little bit different because they're not domesticated. They don't really have an owner. So that's, and Mother Nature is judgment proof, can't sue her. So basically in this situation where we're dealing with animals, we're dealing with dogs, there's two types of things that you look at. One is there's the law we call the mailbox rule, or whatever. If there's somebody that basically applies to postal people or anybody that's legally authorized to be on your property. You invite somebody over your property and your dog bites them, regardless of whether they've bitten anybody else, you as the dog's owner are responsible to pay for the reasonable cost of their medical care as a result of them being bitten. As long as you are authorized and invited onto their property, then you are responsible for the medical care. In order to get additional funds for a dog bite, then you have to look to basically prove that the other party knew or should have known that the dog was going to bite somebody. And that's where the one bite rule comes into play. Is if the owner of a dog, if a dog's bitten someone else, there's the knowledge that they have that they knew or should have known that this dog was dangerous, and they should have done things to take better care to make sure that it didn't injure you. So, but in general, there's other things that you can do to prove that an owner should have known a dog was dangerous. Breed in and of itself in Alabama can be used to show that a dog is dangerous. So pit bulls, Dobermans, Rottweilers, Chows, things like that that are more aggressive types of dogs. The owner is on notice of those traits or characteristics of that dog simply by virtue of the breed.
Okay, so, and then if a dog bites me, there's emotional distress. I'm going to be bent out of shape.
Sure.
So how do I get money for that?
Well, that's what, there's a difference between, the mailbox rule, right? In the mailbox law, if you're on somebody else's property, they've got to pay your medical bills. If you're on their property or you're on somebody else's property and you can prove that the owner should have known that the dog was dangerous, then you can get medical expenses, pain and suffering, mental anguish, permanent injury, scarring, lost wages, the full gamut of damages.
And for that, I would imagine you need a lawyer too.
Typically.
Yeah, I would think so. Listen, if you have a call, give us, if you have a question, give us a call. We'll be back in just a minute. Timberlake, League and Brooks here in Huntsville at 256-536-0770 or 800-804-2502 or go to law-injury.com.
And Sharon will be back with us next week. She practices family law here in North Alabama, the Tennessee Valley, divorce, child custody, modification, those types of things. She does a great job. 256-539-7337, or you can find her at SharonFamilyLaw.com.
Glad to have Sharon back. I've enjoyed sitting in for her for a
Yeah,
little bit.
man,
It's
we
been
enjoy,
great
I
fun.
always have the old pro back on set. It's all good.
We've known each other for quite a while. Listen, thank you very much for joining us for WAAY 31 Law Call.